My name is Ken Levinson, and on behalf of the Board of Directors of WITA, we'd like to welcome all of you here today for the sixth event in our 10-part NAFTA series. So far we've looked at issues, agriculture issues in the NAFTA, manufacturing, supply chains, dispute settlement, Chapter 19. And today we look at the issue of what happens if the U.S. unilaterally withdraws from the NAFTA. Our next NAFTA series event will be on December 7th, when we'll look at energy issues in the NAFTA, and are pleased to be joined at that event by former Congressman Charles Bustani, who will moderate the discussion. Information on that event and other events are in their packet that you have today. Special thanks to the National Pork Producers Council, who sponsored the WITA NAFTA series. We're very grateful for their support for WITA's educational mission. And if there's other, we have a lot of other activities coming up next year. To talk to myself or Diego, happy to fill you in on that, and sponsorship opportunities, including our Next Gen Trade project. Now to today, I was talking with Vanessa. We were trying out a couple of jokes we might try to use for today's event. I was thinking myself about that old Harry Truman line. I don't know whether it's true or not that he said he wanted a one-armed economist because he was sick of them saying, well, on the one hand and on the other hand. So and then that was, we have four lawyers up here and an economist, so I wasn't quite sure where that one was going to land. Then I was thinking about a different one, which was you have the rabbi, the priest, and the atheist walk into a bar. I guess in this case we'd be talking about four lawyers and an economist walk into the Oval Office to talk about NAFTA withdrawal. With that today we have four lawyers and an economist. After we hear from our panelists, and I won't be telling any more jokes, we'll have a discussion amongst the panelists. Yeah, thank you very much. What's that? What does it take to what does it take to pull me off the stage? A little neck thing. This is not a joke actually, we did do a Twitter poll last night on what would people think would be the outcome of if the president were to withdraw. So the four choices were zombie NAFTA, separate bilaterals, Congress blocks withdrawal, and courts block withdrawal. And the winner was Congress blocks withdrawal. So I'm curious to see. That was 43% with that. Courts block withdrawal 20%, separate bilaterals 20%, and then the zombie NAFTA was the last. I think Sean Donnan wrote a piece on zombie NAFTA. I guess you can look that up. Maybe during the event you can look at WITA's Twitter feed and add your vote when you listen to people what they have to say today. After the opening remarks, we'll have a discussion amongst the panelists. Then Vanessa will take questions from the audience. With that.
Okay, so I'm Vanessa Sciarra from the National Forestry Council. Thank you to Ken for sponsoring this topic. It's a topic of much interest. I think I must get 3 or 4 emails a day about this, or phone calls. So it's a topic that's near and dear to my heart, but I was thinking about sort of setting the table for this, and I think this was a pretty hypothetical discussion until a night in April. Many of you will remember that night, late in April, when there was a furious rush to weigh in with the White House because we now know there was a discussion, a very serious discussion about whether the president would sign a notice to send to the Canadians and Mexicans. The sort of anti-withdrawal forces won that night, but I think that did to some extent define some lines of the White House, and there's been a pretty rigorous discussion since then, as we understand. So this is a real topic. It's affecting companies every day. And the fact that they're in the fifth round negotiations started today, but there are clearly great divisions among the Canadians, Mexicans, and Americans on the proposals that the Trump administration has filed. So this is real, and this is something that those of us on this panel have given a lot of thought to. So I hope we can share our thoughts with you, and I hope we can start a discussion about that. Before I give the mic over to Gary, let me just do a brief introductions on my panelists. So Gary is sort of a dean of the trade policy world. I'm not going to go into his long and extensive resume, but I will tell you he now is the Reginald Jones Senior Fellow at the Peterson Institute for International Economics. He's had a truly remarkable career, including positions at the Council on Foreign Relations, Georgetown University, and the Department of the Treasury. So he will be our first speaker. He is the only economist on the panel, so he's going to keep the lawyers, well, he's going to keep us in check here.
He's also a lawyer.
And he's also a lawyer, okay. But he's an economist today. And then next to him is Aaron Barnes from the Cato Institute. Aaron works with Ilya Shapiro at the Robert A. Levy Center for Constitutional Studies, and they have spent recently a lot of time thinking about the constitutional issues, so he will address those. Next to Aaron is John Veroneau. He is a partner at the law firm of Covington and Burling. John has an impressive resume, including serving as a general counsel and deputy USTR. And he has also held senior positions for Senators Cohen, Frist, and Collins. And finally, last but not least, Steve Clays, currently a partner at Wiley Ryan. Part of that, most recently, he was trade counsel for Ways and Means, and part of that, he held senior positions at the Department of Commerce in the White House. So a really impressive panel. We've sort of divided up topics, as you will hear, and then we'll start. I'll do some questions, and then we'll take questions from the audience. So with that introduction, Gary.
Well, thanks very much. It's great to be here. Thanks to Ken. And I see a lot of old friends, not only those on the panel, but I see Amy Porges back in the back, and Bob Vestine, and John Francois, and many others. So a tremendous room of expertise and old friends. Great to be here. Well, from an economic standpoint, I guess we really should start with the geopolitics. We're in the biggest episode of self-inflicted withdrawal from the global economy that I think any country has seen, well, since when? I don't know since when. So this has enormous geopolitical consequences, but let's turn to the economics. I think the first thing that the U.S. withdrawal, not only from NAFTA, but from WTO and so forth, has done is actually to revive interest or spark interest in the regional accords which are underway. Clearly the TPP-11, those countries didn't quite take on board Secretary Ross's statement that without the U.S., TPP-11 was dead in the water. They're going forward to do it. RCEP has kind of a new life thanks to the Chinese initiative, and quite interestingly, the Pacific Alliance has been energized, and there's even talk between Mercosur, basically Brazil, and the Pacific Alliance about a possible huge South American grouping. So I think that's all, in a way, been energized by the new U.S. mode on international trade. And I think it's helped the EU-Japan initiative along. The WTO, however, as a result of what the U.S. is doing in NAFTA and more generally, is pretty much dead in the water unless another global power, that would be the EU, or China steps in, which they don't seem to be about to do, or possibly a coalition of willing small countries which have in the past taken leadership roles in the WTO. That would be the Nordics, Australia, and a few other small countries. The same would be said for TISA, Trade and Services Agreement, which Bob Vestine was so instrumental in launching, and the Environmental Goods Agreement. But it takes one of these major powers or a coalition of small powers to get those forward. So I would say the WTO is not bright. Now for Canada and Mexico, whatever comes out of this, it seems very likely there'll be a drop in inward investment into those two countries, particularly into Mexico. That's unfortunate, but that's kind of seems to be in the cards, whether there's a zombie NAFTA or, just uncertainty, whatever. Now, with the NAFTA withdrawal scenario, the extent of new nationalism in government procurement is just rampant. We did a book a few years ago on local content requirements, of which government procurement is kind of the core, and this is the golden era of local content requirements. What the U.S. is doing with Buy America is, inspiring to many countries and in that realm. So there we have it. There's also, I think, as surrounding the NAFTA withdrawal, is kind of a general skepticism globally on M&A, and that's being reflected in the Corn Bill here in the U.S. Now, so in this kind of outlook for trade policy, I think the big surprise would be a revival of world trade expansion at pre-2007 rates, which was basically world GDP growth plus 2%, 3%, even in some years 4%. To get that revival seems out of sight, though this year it looks like world trade will be growing as fast as world GDP. A related big surprise would be serious liberalization of services trade, which is the new frontier of trade in the global economy, but unfortunately the barriers to services trade are high and don't seem to be going down unless we get a revival of TISA. And so I think you could say the same on digital. There are no rules on digital, but it doesn't look like we may get many new rules on digital flows either, so governments will do what they can to restrain those flows. Yet, I would say, as bad as the NAFTA withdrawal is as a signal, and I would put with that Brexit, I think Brexit and NAFTA are just hand in hand. I don't think at this stage yet, I wouldn't see a global escalation of high-profile barriers that would lead to a significant drop in trade. So there's the crystal ball.
All right, well, good morning. Very happy to be here. So, to start with, I'm probably going to have to do the on the one hand, on the other hand thing, because unfortunately there's no clear constitutional provision on treaty withdrawal. There's no text really on congressional executive agreements, which is what NAFTA is. So, and there's no kind of scholarly consensus. It leans a little bit one way, but there's just, at a certain point we're just kind of giving educated guesses. So I guess the first thing that I wanted to kind of open up with, a lot of the kind of research that we've been doing has been geared more towards, if a court did decide these sorts of issues on the merits, how should it be decided? And that kind of leaves us aside the biggest obstacle to Congress being involved in these sorts of withdrawals, and that's just and I hate to use this word, especially for anyone that's been to law school, but justiciability. All right, sorry for that. But essentially, a lot of the case law on these sorts of things have to do with standing and mootness and the political question, that sort of thing, where a court essentially doesn't want to touch these things if it doesn't have to. So that's going to be the biggest hurdle if, as the one of the options in the poll was, if we want courts to kind of weigh in on these sorts of things, that's going to be the biggest kind of initial hurdle. And not to get too much into the weeds here, but the case that comes up over and over was Goldwater v. Carter, where Senator Goldwater and some other senators sued President Carter because he withdrew from recognition of Taiwan. So, and they basically said, well, 4 of the justices said that's a political question. Essentially, that's between Congress and the executive. We're not going to decide it. So, like I said, I want to give y'all something that's kind of useful takeaways. I don't want to do the ivory tower thing of constitutionality, but some of this background is kind of essential. So, standing is a problem because a lot of these cases in the past, congressmen themselves have decided to file suit, and that's probably going to be a non-starter. It's probably going to have to be plaintiffs like some of the people in this room from industry for standing to have a chance. Also, there's the issue of mootness. So in that case, they said, well, Congress really didn't do anything to assert its constitutional thing, so if Congress isn't going to do its job, we, the courts, aren't going to either. So Congress probably needs to take some affirmative action, assuming they want, a say in this, if the president tries to unilaterally withdraw. And then, so essentially, the other thing is the political question doctrine, and it gets into the structure of the Constitution. So all of these cases were on what they call Article II treaties. There's there's something in the part of the Constitution having to do with the executive where, he does a treaty, 2/3 of the Senate has to ratify it. There's at least a plausible argument that congressional executive agreements are different from that the powers come from Article 1, which has to do with the legislature. There's, the Foreign Commerce Clause, where these sorts of things like NAFTA are more legislative in nature. They don't have to do as much with national security. They have to do with, making these commerce agreements. So there's at least a plausible argument from that perspective that Congress has a greater role in withdrawal than they would in your traditional kind of treaty. Let's see. And then, so essentially there's two parties traditionally that have brought, kind of suits. And as I said, one has been congressmen, and that's probably a non-starter. The other has been private parties. So just kind of the practical takeaways here. What can Congress do? What can private citizens do? Congress essentially can't sue the president in court, and it also can't pass some sort of statute probably that prevents him from giving notice to Mexico and Canada that he's going to withdraw. It's pretty good case law that he has kind of a exclusive power to communicate with foreign nations. But there are things that Congress can do to kind of reassert itself or to make it easier for private plaintiffs. So the first thing they could do is try to repeal or try to overcome Section 109 of the Implementation Act. And that section essentially says that when the underlying treaty expires, the international agreement, then the implementation in domestic statutes of 101 through 106, it also automatically expires. So they could take steps to say, well, that's no longer the case. They could pass a statute on that, that sort of thing. They could also pass a resolution saying, essentially, we, Congress, think it's within our constitutional power to have a hand in withdrawal. And that would prevent the kind of ripeness issue. It would essentially mean that two branches are asserting their power, and the court would be more likely to decide that than if Congress was silent on that issue. The last thing it could do practically would be to pass some sort of statutes that would just simply re-implement the NAFTA provisions as domestic statutes. So it does have, Congress does have things it can do, certainly. As far as private parties, kind of the tack they would take in litigation somewhat depends on, the preceding things of Congress. They would have standing to sue, most likely. There's the steel seizure cases back when Truman tried to take over the steel mills, and so it's a case called Youngstown. That's kind of the best example of the courts deciding these sorts of things. So essentially, you'd have to show domestic harm, which I think we can all agree would be the case with NAFTA. This is not something where it's going to just affect overseas, like with war powers or something like that. It's going to significantly impact domestic business, so that shouldn't be a problem. You can also essentially argue non-delegation. So you can argue that Congress didn't properly delegate its power in NAFTA, so either the kind of automatic withdrawal of the statutes is not valid, so that sort of thing. That's if Congress doesn't act to actually repeal or undo 109 by itself. And then if Congress does pass that resolution, again, that's going to make it much easier because essentially the way the court looks at it, there's three situations. There's the president acting, kind of hand in hand with Congress, the president acting when Congress hasn't spoken, or the president acting against Congress. And right now, what it probably looks like is, based on the implementation statute, that Congress has kind of given him some powers to act. If they pass a resolution saying, well, no, we think we have a hand in this, then it takes it from that first category where he has, an enormous amount of power to kind of the lower category where he has to act pretty much based on either his inherent powers or the powers specifically delegated to him. And again, the Commerce Clause is very clear that foreign commerce is a legislative thing, not a presidential thing. So I just kind of wanted to, those are going to be kind of the issues that are in play, and some of the kind of the practical actions that either Congress or private parties could take if the notice to withdraw is delivered. So that's what I've got.
Good morning, everyone. Ken, thanks for hosting this event. Truthfully, I wish we weren't meeting here talking about this topic, but here we are. Ken, by the way, for any of you who have been a panelist on one of Ken's events, he's meticulous and no detail is left to chance. Although I must make a point of order here that the color of this chair, Ken, is pretty loud. If I had known, I might have worn matching socks or at least a tie, something that, goes properly with this. And so next time, maybe a little attention to that detail. So let me pick up a little bit where Aaron was with regard to the president's authority. The president's authority with regard to foreign treaties, and I use treaty here with a small t, as opposed to treaties exclusively meaning those who go to the Senate for ratification, for approval. NAFTA is a treaty from an international law perspective. It is, the president has authority, in my view, to withdraw the United States from NAFTA. Congress has obviously the most explicit rights in the Constitution with regard to foreign commerce and tariffs, but those powers are not exclusive to Congress. The president does have authorities. And so over the years, I remember many times, and Steve, you may have been in a similar situation where people will describe fast-track authority or TPA authority and say, well, that authorizes the president to negotiate trade agreements. And I, many times corrected reporters and others, said, no, the president has constitutional authority to enter into international agreements. Obviously, the president doesn't have authority to change U.S. law to the extent that it is necessary to change that law to comply with the agreement. So for that reason, Congress is necessary for trade agreements because, at a minimum, they affect tariffs. But the president has constitutional authority to negotiate trade agreements and other international treaties. And in my view, having done the legal research and the constitutional law research, the president has the authority to withdraw the United States from it, and our trading partners, in this case Mexico and Canada, would have no choice but to acknowledge that the president has acted on behalf of the United States, because as the U.S. Supreme Court has said, the president is the sole organ of foreign policy. So I personally don't think it's much of an open question whether the president has this authority. And as importantly, as Aaron mentioned, a court's willingness to take a case challenging such a decision by the president, I think, is highly questionable. It is a political law question, and the case law would suggest that no court would get in the middle of that one. I think what becomes more interesting is, okay, what are the legal implications of the president withdrawing? Put aside the political implications or the economic implications. The legal implications are a little less clear. The implementing statute for NAFTA, again, just to be clear, NAFTA does not exist as a creature of statute. The implementing legislation authorized the president to do certain things to implement the legislation. And I use the word authorize loosely, it's the term used in the statute. And there are certain things the president was authorized to do. For instance, he was delegated proclamation authority with regard to tariffs, which only the Congress could authorize the president to do because Congress very clearly has that authority. There are other things the president did in furtherance of NAFTA that the president does not need Congress to delegate powers to, but clearly with regard to tariffs, the Congress delegated that authority. But those delegations were in the context of the president may proclaim certain duties to implement the act. Many of those proclamation authorities expired, but even to the extent that they didn't expire, those delegations of authority were for a very specific purpose, to implement the act. And in this regard, I think the Constitution is clear that Congress has exclusive authority on tariffs. To the extent they make any delegations to the president, I think any review of those delegations would be narrowly interpreted, because the president shouldn't be doing things with regard to tariffs that weren't clearly delegated. And to the extent that the delegations in the NAFTA implementing legislation were in the context of the president can do certain things to fulfill the obligations of the agreement, that's one context. Whether he can do things that don't fulfill implementing the act or the agreement, but are in furtherance of withdrawing the United States from it, I seriously question whether those authorities, those delegations, survive. So once you net it all out, I think where we would end up if the president were to exercise his constitutional authority to withdraw the United States, I think the tariffs under Section 125 of the 74 Act would stay in place. The NAFTA tariffs could stay in place for a year. There's a question whether the president could move more quickly to have those NAFTA tariffs suspended. But if the president doesn't exercise that authority, NAFTA tariffs would stay in place for a year, and then they would default to WTO tariffs, or in the case of Canada, a little known fact, but a fact that's now becoming more and more aware, is the U.S.-Canada Free Trade Agreement never really expired. It is a living agreement, and my view is that if the president withdrew the United States from NAFTA, tariffs vis-a-vis U.S.-Canada would default to the U.S.-Canada bilateral agreement, because that agreement is still in place. I know there's a view of some that Congress would have to take some affirmative action in that regard. I'm not so sure about that, frankly, so my view would be it would default vis-a-vis NAFTA, vis-a-vis Mexico to WTO tariffs, vis-a-vis Canada to U.S.-Canada agreement tariffs. But aside from the law, constitutional law and the statutory law, my hope is that the Congress would assert